Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Brandon Magner, a 2018 graduate of the University of Kentucky College of Law, who is practicing union-side labor law at GAF Law Office in Indianapolis, Indiana, where he represents workers in the building and construction trades as well as other industries. We will discuss his article, Grand Theft Auto, Calibrating Laboratory Conditions to the New Normal in Union Elections, which will be published in the Concordia Law Review. So welcome to the show, Brandon.
Hey, Brian. Thanks for having me.
Yeah, and congratulations on getting this article written and out the door and in the publication queue. That's really so great to see a recent graduate of the law school engaging in legal scholarship like you are.
Yeah, I just I went ahead and I wrote this during my 3L year for an independent research course, and after graduating, I just had it laying around, and the issues within the article were still buzzing around in my head all the time. And I just thought, why just not try and dust this off and send it off to law review and see what they think. And so
it's great. It's great. And it's super timely too, as we'll get into later in the conversation.
Right. Which made, it was timely when I wrote it, and then it's timely again for reasons we'll talk about. Not all good, but still very important, I think, for labor law reform going forward.
Cool. So as we were discussing earlier, maybe you could start by sort of talking more generally about like what labor unions are, how they work in today's kind of industrial labor market, and how a union kind of comes into being in a particular workplace. Right.
So a labor union is basically a group of workers specifically within the American context. A union operates solely within one workplace, so one company at the enterprise level, as opposed to in Europe, you'll often see unions cover an entire industry or sector. So it's a group of workers that will bargain with the employer for better wages, hours, conditions of employment, benefits, and all sorts of things. Everything rising from retirement packages to something as small as whether you want an ice cream cone machine or something in the break room. That is something that the employer may have to bargain for, depending on the context of the individual workplace. And unions today are not nearly as prevalent in the American workforce as they were even 30 years ago. At their peak, they represented about 35% of the workforce in the 1950s. And today, the private sector unionization rate is down to a little around 7%. So they're not nearly as the union bargaining prevalence within the American economy is not nearly what it was. So it's easy for us, I think, to kind of forget about what they do. And it's true. A lot of people my age certainly don't even, I think, know what unions are or what they do.
So in a sense, it's almost like a union is kind of like a company within a company that represents the workers collectively then?
I haven't thought of it that way, but I think that's one way to describe it is it's without a union, you operate under at-will employment in America as the default presumption of employment. And it's just you individually technically bargaining with the employer for working conditions. But usually, as we know, that is technically, or in effect, whatever the employer offers you is what you get. And the only way to really change that default rule is to organize you and your coworkers into a union, because then the employer under the law has an obligation to bargain with you and the group of your workers for a contract, a collective bargaining agreement.
So are there like both practical and legal benefits then? I mean, it sounds like there's laws sort of regulating how employers have to negotiate with unions. Are there also like practical negotiating benefits? I mean, like, for example, can a union have more leverage than workers would have on their own?
That is something that's sort of a disagreement, I guess, depending on your ideology, depending on your view of the economy and stuff. my opinion at least, is that there's no doubt that workers have more bargaining leverage together than they do individually, just through the simple sheer numbers. Is that if you say to your employer, if you have 50 coworkers and you individually say to your employer, I refuse to work for the conditions that you have offered, he will say, okay, get lost. I will hire somebody else to do it. Unless you're a very high skilled laborer, you offer some unique set of skill. But with you and your coworkers, if all 50 of you in the workplace say, we want better wages or we will go on strike, then suddenly the employer is looking at not having any employees showing up to work the next day. So, I mean, that's just, to me, it's kind of fundamental in just the idea of collective action, collective empowerment.
Mm-hmm, mm-hmm. So how does this work then? Like, how does a union actually come into existence? And in particular, what does a group of workers have to do in order to qualify for treatment as a union under the law?
This is something, the legality of union formation was first, I guess, given federal sanction in 1935 when Congress passed the National Labor Relations Act. And part of that was it established the National Labor Relations Board, which oversaw the election and certification of unions. Before that, it was purely a voluntary basis of whether the employer would recognize the union or not. So basically, you had a dichotomy where super high skilled workers who had a lot of individual bargaining leverage, and together, when they had a lot of bargaining leverage, they were able to force the employer basically to recognize them as a union. But less skilled workers, people say, who worked assembly lines, who had what was seen as replaceable skills, they rarely ever had unions. So the National Labor Relations Act is what changed that and allowed workers to petition themselves to the NLRB to certify as a union. And so what that requires is you need to have 30% of the workers in the workforce need to petition to the National Labor Relations Board to say, we would like a union election. And in effectively, a union will only do that if they believe they have a majority support of the workforce, because the union can only be certified through the NLRB if they win 50% plus one of all voters participating in the election. So if you get that 50% plus one status, then the NLRB will certify you as the union. And then the employer becomes obligated under the law to bargain with you over wages, hours, and working conditions.
So what's the constituency? Like, who are the people who are counted as potential union members for the purpose of an election of this kind? And are there some people who might work for a business who would not be included?
Sure. So I guess literally is anybody who the union places forward is the constituency. But like you alluded to, there's a lot of subtleties to it that I guess can carve up the bargaining unit into a smaller unit. But management cannot be part of the bargaining unit. Independent contractors cannot be part of the bargaining unit. Professional employees in some contexts cannot. So there's a famous Supreme Court ruling that says that actually professors at universities cannot be part of a bargaining unit. So that's what creates the split between professors and teaching assistants. Judgments that are made determining of who can be part of unionization and who cannot. Which also, so supervisory employees also cannot be part of it. So like foremen at the assembly plant cannot be, they're considered kind of the helpers of management. So even though they kind of are on the shop floor, not in an office or anything, they will not be included in any bargaining unit.
Okay, so how is a union election supposed to work? Like, kind of in the kind of theoretical world, what's supposed to happen? What's it supposed to look like? And like, to what extent does the NLRB or any other kind of government actor have a role in regulating how a union election proceeds?
So the NLRB, in a perfect setting, the union is supposed to petition for an election, and then both parties, the company and the union, will then make their pitches basically to the workers over the course of a few weeks, arguing for and against unionization, its pros and cons, and then the employee is supposed to make an informed choice based upon those pitches. The NLRB sees this as it's sort of a criticism often emerging in labor law, is that the NLRB sort of vacillates between treating it as an analogy to a political election, where the workers are the voters, the company and the union are the politicians of the political parties, and they're making their campaign speeches. And then on the flip side, sometimes what they'll treat it as, or what doctrine they view it under, is called the laboratory conditions. And that is sort of the assumption that the union election is a closed experiment that needs to be closely monitored so that we can get the right measurement of employee sentiment. And so anything that disturbs that measurement, whether it's fraudulent information given by the company or union that misleads the employees, or coercive tactics used by either side, then that becomes something that has disturbed the laboratory conditions enough that we didn't get an accurate reading. The final result, whether they voted for or against unionization. And that may require then, under laboratory conditions, a rerun of the election.
Okay. Well, let's return to that in 1 second. But I wanted to kind of take a big picture look at sort of the unionization process in the United States right now. So you suggested, or you observed earlier, that the prevalence of unionization in the private workforce has been, kind of steadily declining over the last couple of decades. Why is that, right? I mean, are there structural or legal barriers to unionization, incentives that might be preventing employees from unionizing? Is it a geographical phenomenon? In other words, is the decline happening more in some places than in others? And if so, why?
It's definitely a mixture of a whole ton of factors, political, social, economic, but it's been a very, as you alluded to, it's been a very linear decline in unionization since basically the middle of the 20th century. And I'd say the biggest economic factor for that is obviously globalization, just in the fact that factories or large employers are it's much more easier now for them to move their production overseas, to move it within the United States to a different state, based on their own interests. And so that freed up a lot of former bargaining leverage that unions used to have, where they could if they had enough collective strength, they could kind of exert their will over one employer at one workplace. And now it is much easier for the employer to say, well, I don't like how the union is driving my rates up, driving my wages up. I have very expensive benefit packages now I have to pay out. So what I can do is I can move my plant to, say, the South, where there is a much lower unionization rate, much less competition politically. The environment there is much more against unions, just historically, ideologically. So they'll have much less support there, both in the workplace, both among the workers themselves and in the local governments. So it's just kind of created this atmosphere where even if unions are successful in one region, if they become, say too successful, say they drive up the wages like they did at what is traditionally called the Big Three, Chrysler, Ford, General Motors up in Detroit, Michigan, is that the workers there had very high benefit packages, very high wages. And over time, they were seen as being less competitive with the increasing foreign competition that moved into the United States from Japan and other countries. that then made those companies, or at least they were perceived to be, less able to compete with the lower labor costs that the foreign companies were able to operate under. So it creates this race to the bottom scenario where companies can move their operations south to, say, a state like South Carolina that has only 2% of its workforce is unionized versus somewhere like California, New York, where it's upwards of 20%, where because workers are not able to prevent the companies from doing that, they're honestly bargaining against themselves to a point if they are driving up their own wages too much, or at least that's the economic argument.
Mm-hmm. And you've noted something called right to work laws as well. Can you talk about what those are and sort of where they're most prevalent and whether you think that they might have an effect on the ability of workers in particular industrial settings to unionize?
Sure. And I'll preface it by saying that the name itself is misleading. There is no right to work really anywhere in the United States. So you don't have a right to a job. You don't have a state passing a right to work law does not mean you can go walk into any employer's office the next day. I have a right to work here. The name itself comes from the argument that, or the reality that in a non-right to work state, a union can, in the workplace, a union can compel what are called agency fees, or what they like to call fair share fees, from everyone who operates under the collective bargaining agreement within the bargaining unit. And the logic for that is that even if, say, you aren't a member of the union, we don't have compulsory union membership in the United States. It's on a voluntary basis. But in a non-right to work state, even if you elect not to be a member of the union, you will still have to pay from your paycheck somewhere between 1% to 2% of it to the union, because the union is the one who is administering the collective bargaining agreement, is the reason why you have higher wages, just cause job security instead of at-will employment. They will represent you in grievance settings for arbitration. Even if you're not a member, the union has to do that under its duty of fair representation. And so it creates this kind of, it prevents a free rider scenario, common under economic theory, of where if somebody doesn't have to pay for what is essentially a public good, they will not do it. And that is higher costs on the union, because they will then be representing more and more people who rationally choose not to pay that fair share fee. And so what right to work laws do is they eliminate that level of compulsion where you do not have to pay the union anything, but the union remains obligated under the NLRA under its duty of fair representation to represent you. So somebody who's not a member of the union can file a grievance against their employer, and the union will then have to go pay somebody like me attorney's fees to represent them in an arbitration setting. And so the union argument is that that is unfair. But what the right to work law does is it eliminates that level of compulsion, and it creates this sort of level of animosity inherently in the workplace, where people who do pay the union fees then feel like the free riders aren't paying anything but getting the same product. And but really, just being honest though, that itself alone is kind of a specific legal tweak that doesn't necessarily destroy a union overnight. It's the right to work law is more of a signal, I think, to employers that we have the political support for you against labor in our state now. Come move here. Come bring your plant here. We will pass more laws that benefit you. And research shows that employers are much more likely to move their facilities to a state that has a right to work law than one that does not.
So a big part of your paper, Brandon, is looking at some recent attempts to unionize at auto plants in the South, almost like case studies of what a union election drive looks like today. And I wonder if you could talk in more detail about sort of what happened in those union elections and how they relate to the sort of theoretical goals of how a union election is supposed to be run.
Yeah, and so these elections actually touched on this race to the bottom principle that we were just talking about, and they really, really symbolize that. The first one being the 2014 United Auto Workers drive at Volkswagen in Chattanooga, Tennessee. And this one was uncommon in the sense that the company itself did not campaign against the union, because Volkswagen has a very strong international union presence that I think influenced management's decision not to pursue, as it is legally obligated to do under labor law, to campaign against the union and try and persuade workers not to vote for the union. But what filled the void, really, of the usual company campaign against the union was a very strong, combined, overwhelming campaign against the union by local business interests, local political and the local political establishment. So what emerged was the governor's office there, the Republican-controlled legislature, and former senator and former mayor of Chattanooga, Bob Corker. They all campaigned and collaborated to really send signals to the workforce that a union was not wanted there, and it became very publicized. And what eventually became revealed was that the Speaker of the House in Tennessee actually made communications to the manager of the Volkswagen plant that they would withdraw the $300 million in tax subsidies that they had originally appropriated for Volkswagen for a plant expansion if they voluntarily recognized the union, as they originally planned to do. So that's what created the need for an NLRB election, was the fact that the company did not recognize the union. So for the union to gain certification, they had to go through the usual NLRB machinery. And on the eve of that election, Senator Corker actually said that he had it on good authority, and he had sources within the plant that said if the workers voted against the UAW, Volkswagen was going to announce a new plant expansion. They were going to bring in a new line of automobiles that would hire 1,000 more workers. And so that kind of caught the workplace by storm. And what ended up was they ended up losing that election by about 70 votes. And in a plant of around 3,000 employees, that was a very small margin. And so what that eventually led the union to try and do this legal argument that under laboratory conditions, the laboratory conditions doctrine that we were talking about, where the NLRB sort of acts as the overseer of an experiment, where parties cannot try and taint the results through misleading information, that this kind of combined efforts by the politicians in the state and the local business interests that affected employees' freedom of choice enough that they should rerun an election. And they eventually abandoned that argument 2 months later for a reason, another tweak under labor law that says that if you lose an election, you then have to wait 12 months to try and petition for another one, unless the NLRB itself orders a rerun. So the UAW didn't want to try and, because they had such a close result, there was a lot of incentive for them to try and not push this off for years with court proceedings through the NLRB and then through the Court of Appeals, trying to win on this kind of really small legal argument when they believed that they could just try and win on their own merits a year later. And ended up that Volkswagen ended up recognizing the union on a members-only basis, which is not a full certification under law, because the union has to normally represent members and non-members. So there was this kind of truce for a little bit at Volkswagen before the UAW was able to organize, under normal procedures, a much smaller unit within the whole workforce, a small amount of mechanics. And that kind of set off the Volkswagen management that the UAW was withholding their end of the treaty. And so they fought that very vociferously because they wanted the UAW to either organize the whole plant itself or have nothing. The UAW this year, a few months ago, they swore off that smaller unit and said, "Okay, we're ready to have a full election again." And this time the election was far different in that the company campaigned against the union itself, but it also drew upon the same political establishment support that it had previously, in that Volkswagen actually brought in the governor of Tennessee to speak at a captive audience meeting of workers, where it sent a very clear signal that we have the support of the governor, who has control over the political establishment in Tennessee, which can basically determine what kind of tax subsidies we get. They hold the purse over whether our plant can expand or constrict. And that's the sort of thing that the NLRB would typically be looking under laboratory conditions for, things that upset the balance of what messages the employees are supposed to be hearing. And a few years ago, UAW also tried to organize the Nissan plant in Canton, Mississippi, which was a similar setting, in that, a state that doesn't have a very large union presence, where it's important for the UAW to try and organize that to try and protect its wage gains in other states. And the Nissan campaign also saw a very strong company campaign against the union. They had the support of the governor. They had the support of a lot of DC 501c3s that actually bombarded employees with mailers, commercials, radio spots, things that kind of created this just cacophony of messages and arguments against the union that otherwise would normally not be there. And so it creates this difficulty under labor law, where the employee is supposed to be hearing what is imagined to be sort of reasoned arguments from both sides, but what the employee is hearing is, okay, my employer, who controls my paycheck, my schedule, how much I make, how much I work on any given week, they're telling me to vote against the union. Then also the politicians in my state, which obviously hold a lot of power, they're telling me to vote against the union. So what is really convincing me at this point to upset the status quo here, to bring in a union? I mean, that becomes a huge risk for the employer. I mean, just being honest. I mean, that becomes something where it would then take a huge effort or a huge upset victory by the union to try and organize a union in a place that does not traditionally have unions, that does not have the support, the infrastructural support, or anything similar.
Yeah, I mean, I can see how that would be incredibly frustrating for a union like the UAW to have all of these outside voices intervening in the workers' decision. That said, I mean, it seems like, is there the possibility that there would be like free speech, First Amendment related issues sort of intervening there as well? I mean, I can see why you wouldn't want local politicians and frankly, the state governor. It sounds like basically everyone in the state government in these cases is chiming in saying, don't do this, right? Like, that's got to be influential. And yet at the same time, you don't want to be telling people, well, you're not allowed to talk about this politically important sort of decision that's getting made.
Right. And that, yeah, right. And there is a First Amendment argument there, because when the NLRB first came around in the 1930s, it would actually certify unions without allowing any campaigning against it by the company, because they viewed the employment relationship itself, where the employer controlled, where the employer was able to exercise through its property rights under state law, a lot of power over the employee that is not analogous at all to a normal political election where two sides are kind of campaigning for your vote, but they don't necessarily, if one party doesn't win, the other party then just doesn't get to still kind of control how many hours you work on the clock, how much you make. I mean, so the NLRB would actually invalidate any election where the employer voiced opposition to the union. And that ran into First Amendment problems to the point where the Supreme Court eventually said that an employer has a right to voice opinions against the union, that as long as they do not interfere with employees' Section 7 rights under the NLRA, as long as they don't interfere or coerce the employees from exercising those rights. So now the employer does have a right to campaign against the union, so long as they do not interfere in those rights. However, there is no right for third parties. So there is no right for a employer necessarily, or for a local politician to say that you should or should not have a union in the workplace without the NLRB saying that has tainted the results. They are not seen as a party to the election, so they have no inherent interest in it. So the laboratory conditions doctrine, if applied in the way that I argue in the article, would say that if a sort of concerted effort by local political and business interests to try and interfere within the election itself and try to coerce employees against voting for the union, that would be deemed to upset the laboratory conditions enough that a rerun of the election would become necessary.
Right. I mean, it seems like a big part of your point is that this analogy to a regular political election is really strained to the point of not describing the circumstances that are really presented, and that it needs to be thought of differently in order to accomplish the goals of an election, of what the election is supposed to do in the first place. So what would that look like in practice? Like, what would the NLRB have to do differently in order to pursue that kind of approach to thinking about union elections?
Well, just in the way that I strictly speak in the article, I argue for a very small tweak, which is just to find that the sort of concerted efforts I was talking about from third parties would constitute a rerun of the election. And that's not necessarily new. Since the late 1940s, when the laboratory conditions doctrine came into existence, the NLRB has policed third-party efforts in elections and rerun elections if they have been deemed too coercive. To the point where one of the favorite examples I read was that within a union was trying to organize a workplace within a community, and a local owner of a bank was so against the union, he actually began denying loans to anybody who he heard was supporting the union. So that's something extremely coercive outside of the normal company campaign that would be deemed worthy of overturning the result. What hasn't happened, though, or at least not to this point, the NLRB has never held in the sort of setting that I've spoken of, or that I brought up with Volkswagen and Nissan, where local political establishments have run a really coordinated operation against the union. So they have held in the past that stray comments made by, say, a state representative, where they have sent a letter to the union saying, I support your rights to unionize and under labor law, and I hope you support the union. They have said that didn't taint the results, because that was just kind of a small comment made that wouldn't overwhelm the employees' freedom of choice to the point where rerunning the election would become necessary. But they haven't before had sort of on their plate the level of coordination that I've talked about, where, a United States senator has said, I have on good authority that the union, as long as the union loses the election, Volkswagen is going to expand its plant. But if they don't, then they're not going to expand the plant. And so the NLRB, by not policing that or just letting that go, really incentivizes that kind of campaign to be run in any election going forward. Any election that the local community deems important enough, at a plant as large as Volkswagen, at a plant as large as Nissan. Imagine a future scenario where an Amazon plant that employs thousands of employees, if they're undergoing a union effort, that then honestly, if run by, if the community has majority Republican representation, those politicians they have a strong incentive to argue against the union under the current NLRB process. And so it's not necessarily that the NLRB has said, no, this does not violate laboratory conditions. I'm arguing that this should be a priority. This should be something that they view as something that they need to step between, or place themselves between, and say that this kind of election is not viable going forward, that we need to hold that these things violate laboratory conditions. But what you were speaking of earlier is that I'm not the first one to make the political analogy. That's been something around for several decades within labor law scholarship, where people have pointed out that this really isn't similar at all to a political election. In a union election, it's totally legal for an employer to hold at what is called a captive audience meeting, where they take as many workers that they want during working hours, place them within a room, say, you can't leave, you have to stay here and listen to this. And they will then give them an anti-union message, say, this is why we do not support the union. And as long as they don't go towards a really extreme step of saying, I will close down the plant if you don't vote for the union or something similar, then they don't violate any unfair labor practice by simply holding that captive audience meeting. But on the flip side, the union, by being an outside interest, by not having any property rights over the employees, they cannot compel employees to listen to their message. And so that's just a huge imbalance inherent under labor law, where the employer, through exercising his property rights, is able to compel employees to listen to what he has to say. Meanwhile, the union gets placed in the position sort of becoming this feeling of an imposter, where they're having to organize in the shadows, they're having to knock on doors, they're having to call at night, they're having to, so it inherently creates this image of the union as something that shouldn't be there potentially, or at least the default setting for an employee in that setting is the company has a point here. Why would I want them? Why would I want an outside third party coming in and trying to tell the employer how to run his business? So I'm arguing for a very small tweak in labor law, but I think the problems run much deeper, but they have been touched on before. And even if you want to try and throw out the whole NLRB process right now or in the future, right now, these elections are being run at really major focuses for union drives going forward. And to the point where just a few weeks ago at Volkswagen, they had an election that was lost by 30 votes this time around. And that's why you were speaking earlier about my article being timely, is that the Volkswagen tried to run that election again, or UAW tried to run that election again at Volkswagen and wasn't successful. And these elections are still going to happen going forward. They're going to be as important as ever as unions trying to protect their wage gains made in more union-friendly states from simply disappearing south.
Well, thanks so much, Brandon. This has been really fascinating, and I've learned an awful lot about how unions work and the process of union organizing.
Yeah, thanks for having me. And it's great to talk to you in a friend-to-friend setting instead of simply a professor-student setting. This is a first.
What about Power in the Union? You fancy that?
Sure.
Yeah, based on an old, beautiful old American folk song, Rally Round the Flag. And I stole the melody and rewrote the words. I heard it on a Ry Cooder record on the soundtrack to The Long Riders, and I stole the tune. And later found out, much to my joy, that actually the original song had been stolen from an English hymn. So it was kind of cultural repossession.
Comes full circle.
Yeah. And it's one of the things that they play in the background at Disneyland when you go on the boat through the American history.
Oh,
they
that's
play
scary.
the tune, just the tune. Because someone came out and told me, Bill, they're playing Power in the Union in Disneyland. I'm like, no, it's probably Rally Round the Flag. So
Ooh.
let's have some of that, shall we?
All right.
There is power in a factory, power in the land, power in the hand of the worker. But it all amounts to nothing if together we don't stand. There is power in a union. Now the lessons of the past were all learned with workers' blood. The mistakes of the bosses we must pay for. From the cities and the farmlands to trenches full of mud. War has always been the boss's way, sir. The union forever defending our rights. Down with the black legal workers unite. With our brothers and our sisters, together we will stand. There is power in a union. Now I long for the morning that they realise brutality and unjust laws cannot defeat us. Who'll defend the workers who cannot organise when the bosses send their lackeys out to cheat us? Money speaks for money, the devil for his own. Who comes to speak for the skin and the bone? What a comfort to the widow, a light to the child. There is power in a union. The union forever defending our rights. Down with the black legal workers unite. With our brothers and our sisters, together we will stand. There is power in a union.